Good afternoon, everyone. Sorry for the late start, but we should be up and ready for business. Seems like this is going to be a very virtual calendar. We've got DCS here in court and me and a deputy, so we're good to go. But it looks like all attorneys are going to be virtual, which is fine. And all our defendants will be appearing from one facility or another. I have a 4-position but 3-defendant calendar for, I think, plea and arraignment and revocation, and then 2 co-defendants on a bond hearing. But I think we added at least one more because I see a gentleman from either earlier this week or last week, I think one of Ms. Wood's clients. I'm happy to go in whatever order the sheriff's team needs us. Let me look at the list that Ms. Nelson sent as to who we got and where. Is there a particular order in terms of facilities? Do you need us to do Cobb versus ACDC versus the Rice Street facility first?
ACDC, Your Honor, good afternoon. This is Milton at ACDC.
How are you? You'd like us to do ACDC first?
Please, Your Honor.
Okay. Well, you were the first to speak up, so why not? Let me see who we've got there. Looks like we've got Mr. From what I've been told, we've got Mr. Jones. Is that the gentleman seated with you?
Yes, Your Honor.
All right. Let's add the spotlight there. Mr. Jones, if you would come on up, that would be great. And who is handling Mr. Jones's, who is representing Mr. Jones?
Good afternoon, Judge. He's mine.
Hello, Ms. Wood. I will add you. And then I think, Ms. Nix, you are playing your old role. I don't know if I see Ms. Nix on here, but I think Ms. Dilligard wasn't going to be able to join us today. But wow, we've got Mr. Shapiro on. You're in the wrong space, Mr. Shapiro. Who is representing the state in Mr. Jones's case? Well, I'm going to take you, Mr. Rao. Congratulations. Do you have audio in your space? I don't think it matters how close you are to the microphone. It's either it's on or it's not on. He's working on it. Not one of those IT days. Well, you know what? We can do this plea and arraignment. You may be able, on the state's behalf, just through thumbs up, thumbs down, to be able to manage the plea and arraignment. So, Mr. Jones, can you hear me? Okay. I'm wondering if the issue's on my end. I thought I could just heard you, Ms. Wood. Can you say something again?
Judge, can you hear me?
Yes, I can. Excellent. So we got audio. Mr. Jones, you're charged with shoplifting and simple battery. Today is your arraignment day. We may do more than just that, but it's a day where Ms. Wood, on your behalf, can enter a plea of not guilty or whatever's going to happen, and we can move your case forward. You may have been in jail for a while on these charges, so I'm anxious, and as I bet you are, to make sure that we start making progress with the situation. Ms. Wood, what is the plan for Mr. Jones today?
Judge, while it does look like a very resolvable case, I am asking for a reset. I did file a waiver earlier this week. My team met with Mr. Jones. We're going to get some social services going for him. He's also got a probation violation holding him in as well.
Okay, is that on your radar, Ms. Simpson?
Yes, he has a pending petition, but the case was originally with Judge Williams now.
Okay.
I just received a petition from the supervising officer yesterday.
Got it.
So we were able to submit it for signature.
Okay. Hopefully she'll sign it. That will come here anyway, because it sounds like the basis for the revocation would be the new charges that have been indicted. So I'll handle the revocation if and when we handle Mr. Jones's case here. So I see the waiver in the docket. So we've got waiver. We'll do a scheduling order. What that means, Mr. Jones, is Ms. Wood has already entered the plea of not guilty for you. I will get a scheduling order in place, which will give the prosecutor a deadline to get all the discovery in the case. So a police report, body cam footage, if there's any of that, all that kind of stuff to Ms. Wood. So she can look it over and then talk to you about it to figure out what are the right next steps in your case. It may be that this is one that you're anxious to resolve, and the prosecutor may have a recommendation that makes some sense to you and to Ms. Wood. I'll be here for any of that. Mostly my goal will be to make sure we're moving your case along. Do you have any questions about anything I just said? No? Okay. Mr. Rao, anything from the state?
No, Judge.
Okay, well, your audio is loud and clear now. So we'll get this case going forward. Mr. Jones, one last thing I want to share with you. You may not see the gentleman on the screen there next time we're talking about your case. He's a supervisor in the district attorney's office who's covering for some people today. I don't want you to say, wait, where's the guy I heard from the first time? You'll see me for sure, and you'll certainly see Ms. Wood. She is your personal attorney and your advocate, and I'll be the judge who presides over it, and we will see you soon one way or the other, all right? All right, thank you.
Thank you, Judge.
Is this Ms. Kikendall? Okay. Can you speak up? I can't hear you very well, Ms. Kikendall.
It's Kikendall, Your Honor, and I would just like to announce that we would be waiving the sounding of the charges this morning.
Okay. Kikendall it is. And you are Ms. Steffo?
Yes, good afternoon, Your Honor.
Let me get you on the screen, get Ms. Wood off. Okay. Mr. Rao, are you handling, this is a bond hearing. This is an unindicted case. I actually met Ms. Kikendall when I was presiding. She was brought over, but we didn't have an attorney to represent Ms. Kikendall. There was an attorney for her co-defendant, Mr. McCaslin, from the Public Defender's Office. So they had a conflict and could not represent Ms. Kikendall for purposes of the bond hearing. Will you be handling this one, Mr. Rao?
Which case is this, Judge?
It's on the bond hearing calendar that Ms. Nelson published about a week ago. Ms. Kikendall and Mr. McCaslin are both listed on it. It's something that I don't remember if you covered it. It might have been a different unit. The victim, the deceased, is a minor. So that could be a different unit in your office.
Your Honor, if I may, I believe that ADA McCauley with the Cobb County's District Attorney's Office, they're actually going to be handling this case.
Right.
I'm sorry for interrupting.
No. You're exactly right. I remember when I heard about this from Ms. Nelson, I was confused, but that may explain why Mr. Shapiro was on. So I'm going to put him on the spotlight. Look at that. He's wearing a Cobb County tie.
Judge, it's not Mr. Shapiro. Can you pin me to the case, please?
Oh, is he just watching you do your thing?
Yeah, we have the whole squads on, actually.
All right.
Cobb County.
He just went away. They're going to learn how to do bond hearings in Fulton County?
No, I think they're just curious because they're all very excited about having two people joining their team. So
great. All right. Well, Ms. Kikendall, we didn't get to do the bond hearing when we were supposed to, through no one's fault. You're just entitled to an independent lawyer who isn't a direct colleague of the lawyer who represents Mr. McCaslin. So we're doing now what ideally we would have done at that earlier calendar. Ms. Steffo, I am ready to hear from you in one moment. I need to understand, Ms. McCauley, why it is that your office is handling, I'm assuming it's the entire case insofar as this results in an indictment. So both defendants, not just Ms. Kikendall.
Yes, that is correct, Judge. There was a conflict within the Fulton County District Attorney's Office. So the case was then wheeled to the Prosecuting Attorney's Council, and Cobb County District Attorney's Office was appointed. Because it is a child fatality, it will be handled by the Special Victims Unit in Cobb County. And I am appearing on behalf of the Special Victims Unit in Cobb County.
Great. I appreciate your office taking the case and you making time to do this. Will you be the ADA assigned to it, or that's a TBD, depends if it's indicted, et cetera?
Well, I'm actually extremely familiar with this case because when I was still working in Fulton County, I actually handled the preliminary investigation along with College Park Police Department. It will be myself, ADA Shapiro, ADA Lush, or ADA Rayner, maybe a combination of the four of us that will be handling this case through indictment. We've already obtained everything from the Fulton County District Attorney's Office and are working with the agencies to complete the investigation and intend to present it to the grand jury before the 90th day, which I believe is in February.
Okay. Thank you for that update. Then we ought to be able to go forward. Ms. Kikendall, the only thing we're going to work through today is bond. Ms. Steffo in a moment is going to share with me why she thinks you're entitled to bond. I will hear from her. And when I'm done hearing from her, I'll turn to Ms. McCauley. She will share with me the state's perspective as to whether bond makes sense, and if not, why not. I don't think there'll be any people speaking on behalf of the deceased, because I think that would be you or Mr. McCaslin, but the state is always free to present evidence of family members who've got a perspective, or people connected with the victim who have a perspective on bond. I suspect it'll just be the two lawyers who are working through this. Ms. Steffo, when you're ready. You're on mute.
Sorry, Judge. Ms. Kikendall is 32 years old. She's born and raised in Atlanta, and her entire family is here, including all 11 of her siblings who she's very close with. She had 4 children, but she does have 3 children. Madison, who's 13 years old, Jakaya, who's 10, and Legacy, who's 1. Currently, her kids are with her father and their godmother. She does have her GED, and she was working prior to this. She was doing DoorDash as often as she could, and she was doing hair on the side. The address that's on file with the court is a good address. I have confirmed that she will be living there with her godmother, Miss Brenda Finch. She has very limited criminal history, so there's no likelihood to reoffend. She, from my understanding, only has a misdemeanor criminal history, no felony convictions or felony pending charges against her as of right now. The reason that she was staying in the hotel that maybe mentioned was because she was working on getting an apartment for her and her kids. She's been saving up money so that she can provide for her children, and then focus on her career with hair more so than relying on the DoorDash judge. So we are asking for a bond in this matter for both counts not to exceed $50,000, and we are willing to be on an ankle monitor with the exceptions of work and any legal meetings or medical requirements.
Okay. Thank you for that. A couple questions. You mentioned that the 3 children were with Ms. Kikendall's father and godmother, and then I heard you say that Ms. Kikendall might be staying with the godmother. Is that the same person? And if so, does that mean Ms. Kikendall would be staying where the kids are? And is that something, I don't know if you and Ms. McCauley have been talking at all about this case, but given these charges, having Ms. Kikendall being in the same household as the kids strikes me as a potential source of concern. And so if that was your vision and Ms. Kikendall's vision, I'd like you to address that for me.
Yes, Your Honor. So she would be staying with the same godmom. I do understand the natures of the charges. It does present an issue to the court. I do understand also that the children are having a very hard time without their mother and they want their mom to come home. They don't really understand what's going on and it's been a really big struggle for them. And I do believe that Legacy is 1 year old, and so I believe he was breastfeeding at the time. And I know that that's been a hard adjustment for him to have to be switching. He relies on his mother, and so it was the intention to have her stay with the godmother and be reunited with her children.
Related to that question, you mentioned that the three children were with Ms. Kikendall's father and godmother. Are they in the same household, or does that mean that, for example, the oldest child is with Ms. Kikendall's father and the other two are with the godmother?
My understanding is the oldest child is with the father and the younger children are with godmom.
Okay, and it's the godmother's home where you're envisioning Ms. Kikendall staying?
Yes.
Okay, and tell me your understanding of Ms. Kikendall's connection in terms of parentage, relationship, et cetera, with Mr. McCaslin.
That is her significant other. They've been on and off for 5 years, and they did share the child that passed away. They shared that child together, and they do share Legacy, the 1-year-old child, together.
Okay, got it. All right, thank you so much. Ms. Smith-Mann, good afternoon. Thank you for joining us from pretrial. Can you share any criminal history information you have for Ms. Kikendall?
I sure can, Your Honor. There are 5 cycles. Last arrest was on 6/6/19. ATL, theft by deception. That case number is 20 CR 0028134. There are no felony convictions. There are 2 misdemeanor convictions. Nothing further, Your Honor.
Thank you so much.
You're welcome.
Ms. McCauley.
Yes, Judge, I'm going to provide a brief. I won't go too far into the facts because we are not here.
I'm sorry, you're hard to hear. I don't know if something changed with the microphone.
Do I need to?
No, that's good. You're good now.
Okay.
Now you're good.
I just need to speak up. That's okay, Judge. I'm going to give a brief overview of the facts because I think some of them are relevant to the factors of bond. So this child's death results from the drug overdose on methamphetamine and cocaine that was inside the hotel that the defendant and her co-defendant were residing in. On the day of the homicide, following College Park Police Department's investigation, there were text messages that were located on this defendant's phone of her engaging in active drug transactions for both marijuana and crack cocaine on the day of the homicide. I would be happy to show those to the court. Prior to this child's death, this child overdosed on THC back in July of 2024. There were also text messages recovered off of her co-defendant's phone and this defendant's phone about making sure that neither party disclosed to the Division of Family and Children Services the nature of the child's ingestion of that THC, and also a refusal from both parents to test positive for that THC, and that is documented. Again, the state would be happy to share screen those text messages to the court for the court's review.
You just said something that confuses me. I'm sorry. You said that both Mr. McCaslin and Ms. Kikendall refused to test positive. They refused to take a test when there was a concern about what's going on, or I didn't follow that.
They declined to provide DFACs with the correct information of how this child ingested THC, which is documented in the text messages, that they were aware that it was THC. They were aware of how the child got a hold of it. And they said, make sure, actually it was Ms. Kikendall to Mr. McCaslin, make sure you don't tell DFACs that there's anything in your system. Never admit that to DFACs or anyone else. And then upon review of the DFACs records, both parents said they would not need to take and did not want to take a drug test.
Okay, that was the part I didn't get. Thank you.
Sure, of course. So there was a prior DFACs case involving an overdose, and then the drug activity continued to occur between the co-defendants of selling and distributing narcotics, methamphetamine, cocaine, and marijuana over the course of, I would say, I have at least 6 months of text messages, and they're very actively engaged in hand-to-hand drug transactions. There is also 2 undercover operations that were done by the College Park Police Department, which indicate they were both selling actively while they had these 2 children living in this hotel room and exposing them to their narcotic activity. As it relates to the defendant's criminal history, I have a conviction from 2010 out of Clayton County for disorderly conduct, obstruction, and possession of marijuana. I have a case out of Clayton County from December of 2015 for driving on a suspended license, a theft by shoplifting out of Clayton County from July of 2017. Then I have a DUI that was reduced to a reckless driving out of Cobb County in September of 2021, and then a probation violation in Cobb County as well that followed that DUI or reckless driving conviction. I did not have the theft by deception case out of Fulton County, but I do have more than just one interaction for this defendant with law enforcement, and certainly at least one probation violation. As it relates to the Ayala factors, the defendant has demonstrated, 1, that she poses a risk to the community based on the prior overdose of the child, and then the condition in which the condition and circumstances of this child's death. She was actively engaged in drug trafficking and drug transactions at the time of this child's death. There's a risk to victims and witnesses should she be permitted to be released, and that risk is to the surviving children. There is also some indication that in between this child's death and law enforcement becoming notified by Children's Healthcare of Atlanta and becoming involved, that a family member went into the hotel room and cleaned out the hotel room. There is some surveillance footage that gives rise to that issue during the pendency of this case. And then she does pose a risk of returning to court based on the probation violation, and the steady interactions, I think, with law enforcement also indicate a lack of willingness to follow the laws and return to court as needed. As it relates to her ties to the community, the state does not have anything to disprove that Ms. Kikendall is not based in Atlanta or doesn't have significant ties to Atlanta. So based on all of those factors, Your Honor, and all of this information, the state would request that the court deny bond.
If I'm remembering correctly, and it's been a little while, when we had the bond hearing for Mr. McCaslin, there was a representation that I think it was a backpack that Ms. Kikendall had taken something out of the hotel room and basically tried to throw it away. And I can't remember if what I was told was, we're still trying to figure out if we can recover that, or it was never recovered, or it was recovered, but I just don't know what's in the backpack. What can you, and I think that was separate from what you described, which is another family member swooping in and taking stuff and leaving with it.
We did a trash pull, Your Honor, at the crime scene for whatever came out of the backpack after reviewing the surveillance footage, and nothing was able to be recovered.
Okay. Just curious. Thank you for sharing that. Ms. Steffo, I want to make sure you've got the last word, and I don't decide bond based on allegations, and this is what the state understands the case is about, and they were providing context, but I definitely understand that bond decisions aren't based on, this sounds like it was particularly serious or not serious, but the relevant Ayala factors.
Yes, Your Honor. As to the worry of whether she would report back or not, in regards to the mentioning of the probation warrant or the probation violation, there are several reasons that probation violations are issued. Sometimes they're technical, sometimes they're not. I do believe that she would report. I'm in constant contact with her godmother, and I don't believe that there would be, I apologize, there was office noise. I don't believe that there would be an issue in reporting, and I do think that I also don't think there would be an issue to witness tampering if she's on a 24-hour ankle monitor with only the exception of going to work and medical needs and lawyer meetings. And if you wanted to restrict her from social media, Judge, I think there's plenty of outlets that we could do to resolve that risk and issue that the state has provided to us. But I do think it's important to consider the 3 other children that miss their mom and don't understand why their mom is not there and why they're staying with their grandfather and their godmother currently.
Okay. No, I appreciate that. There are other people in the mix. They're probably also not understanding what happened to their sibling. So there's a lot that's confusing and complicated in their life. Ms. Steffo, last question for you has nothing to do with bond. It's more procedure and our ability to stay focused on the case. If and when this gets indicted, it may get assigned to me. It may go to a different judge. But I will have it as long as it's unindicted and there are questions about procedure or bond or anything like that. Are you on this case and are you representing Ms. Kikendall just to sort out what happens pre-indictment, or will you be her attorney and advocate throughout whatever may follow?
Your Honor, I only handle matters like this up until indictment. I only work in the non-complex division and pre-indictment. So once it's indicted, depending on what courtroom it'll go to, it'll either be a contract C3 attorney or one of the attorneys in my office.
Okay, so just hypothetically, if it was assigned to me, I benefit from Ms. Cabrera being the contract attorney assigned here who handles conflict cases. So in theory, it would be assigned to her. I know you and I don't make that decision, but that's what you're describing to me?
Yes, Your Honor.
Okay, but that's great. I just want to be able to assure Ms. Kikendall, because it sounds like an indictment is soon to come, that when she is then in a different courtroom and she doesn't see you there, she shouldn't feel like, wait, I'm being abandoned. You're doing everything you can on her behalf, but you naturally would roll off this case and either someone from your office, if it's one courtroom, or one of the, as you call it, contract attorneys would then step in and be in a position to advocate for Ms. Kikendall.
Yes, Judge. And I do always make sure that my clients are aware that I will only represent them to a certain point, and then they'll be transferred either to the other attorneys in my office or a conflict attorney.
Got it.
Or another
Okay.
C3.
Got it. Thank you so much. Ms. McCauley, I'm going to take you up on your offer to look at some of those text messages, and I'd ask you, in whatever format's easiest for you to share, to get that to Ms. Steffo as well. But I would like to review some of those before I figure out what I'm going to do. But I also want to preview this for Ms. Steffo. If I do set a bond for Ms. Kikendall, it will have as a condition that she cannot have unsupervised contact with any of her kids. And I am going to need to be real comfortable as to how that's enforced. I don't know whether that means I need to meet the godmother or her father, but I think you can understand why I would be concerned for the general well-being. Which is not me saying Ms. Kikendall isn't similarly concerned, but this is a complicated situation where I think we need to be extra thoughtful about what is best, not just for the short term, as in we miss mom and we're confused, but the long term, as in 10 years from now, we can still want to be spending time with mom because we're still around situation. So that's my largest concern, not that Ms. Kikendall would disappear, but that we wouldn't have a situation in place where the children are able to interact with their mother, but they are also safe, if that makes sense.
It does, Your Honor, and I do understand. I could arrange for you to meet with her godmother if necessary. Okay.
We'll start with the text messages, and then I'll let folks know how I processed that. Ms. Kikendall, here's what that means for right now. I'm not setting a bond for you right now. I'm going to review these text messages. They're not evidence in your trial or anything like that, but it's information I'm entitled to consider. Those will go to your lawyer as well. So she'll have a chance to say, wait a minute, this is not even my client's phone number. It's real clear that that's Mr. McCaslin talking with his mom. But I will look at those, and I may conclude that no bond is how things should remain, or I may decide that I am going to set a bond. If I do, I will likely take Ms. Steffo up on her offer and see how I can figure out a way to speak with your godmother about what the setting would be like if you were staying with her and you were around your kids. Do you have any questions about what I just described? No? They just muted you. Something's not working over there because I can't hear you. Now I can hear you. Get a little closer to the microphone, please.
No, sir. What if I wasn't in the home with the children?
So that would be different, but there's still and I don't know if Ms. Rivers could hear that. Your question, as I understood it, was, well, what if you're in a home and the children are not there? That on its face would address my concern. But the larger issue is, how do I ensure that you are not around your kids? And that's harder to do. Because you could say, look, I'm staying with my uncle, and the only people who are there are my uncle and his wife and 2 dogs. But people have legs, cars have wheels, and all of a sudden your kids are at your uncle's house. And I haven't done my job to be thinking about what keeps everyone in the community as safe as can be. Not necessarily as happy as can be, but as safe as can be. So I'm wrestling with that because that was going to be my initial response to Ms. Steffo. That's why I asked her, like, wait, is this the same godmother where the kids are? To me, that's a problematic solution. And it may be that I come down with something that's not no bond. It's a bond, but you need to find a place where the kids are not going to be. And a condition of the bond would be you may not be around them.
Kids are with, I have 2 godmothers. My youngest, my 13-year-old, my 1-year-old is with my godmom, and my son is with dad. I would be living totally.
So I didn't hear the last part of what you said. I understand that you have some kids with the godmother.
I believe she said that she would be living, like she could live with her other godmother without the children.
Okay. All right. I will keep that in mind, that there is an option where you wouldn't be living with the kids, but I still have the concern I need to figure out if I'm comfortable solving, where you'd still be out, and that does I don't have eyes on you 24/7. And so maybe the kids are around, and maybe that's okay, but we're dealing with a situation where on the surface, it appears it was not okay. You being around your kids, and maybe on more than one occasion. So that's what I'm working through. But I've explained what the process will be, and I will certainly let Ms. Steffo and Ms. McCauley know. And the last thing I want to share with you, Ms. Kikendall, I've sort of already said it, but I just want to make sure you follow it. In the same way that once your case is indicted, you won't be working with Ms. Steffo anymore. It's probably going to be the case that you'll have a different judge. Your case will be randomly assigned to one of 15 judges. I'm one of those 15. So if it's not assigned to me, then you'd be working with a different judge who has the ability. Let's say I decide yes, bond, but $100,000. I'm making that up, but that's what I do. And that's ridiculous, Judge. I could never post that bond. There'll be a whole nother judge who's going to take a different perspective on things. And he or she would hear from your lawyer who's handling your case from that point forward. And that judge might agree to change something. So I'm going to rule at some point as to whether you should have a bond or not and what that bond should look like. That's not the law of the case forever and ever. My colleague is free to say, McBurney got it wrong. I'm going to do something different. Okay? Ms. Steffo, anything else on behalf of Ms. Kikendall?
No, Your Honor.
Okay, thank you for your time and for working on the case. Ms. McCauley, I saw an email flash up from you. It sounds like you have already gotten things to me and Ms. Steffo. Thank you for that. Anything else from the state? I'm sorry, we weren't hearing you. It doesn't show you as being on mute.
Not on mute.
Okay, now I can hear you.
Okay, I said I included the specific page numbers for the text messages I referenced during my hearing in the email. Excellent.
Okay. So until indictment, if there's an issue from the state side with the case, reach out to Ms. Nelson. After indictment, we'll see where you land. But thank you again to your office for doing some of Fulton's work. I know you've got plenty of your own.
I still have isn't the other defendant on as well today, Judge, but I'll stay on for that.
No, stay on. I'm not quite sure why he is, but I saw Mr. Cozzoli is here, so we'll talk about that. But I wanted to clear the decks for ACDC first since they had raised their hands. So if there's no one else at ACDC that we're supposed to work with today, thank you, ma'am, for signing on. You guys have a good weekend.
Bye-bye.
Bye-bye. And Ms. Steffo, yes, go ahead.
I was just going to ask if I may be excused.
Yep, we were going to say the same thing. If you don't have anything else on the calendar, thank you again for being here.
Thank you, Judge. You have a great day and a good weekend.
You too. Bye-bye. All right, let's turn to our Rice Street inmates. Ms. Wood, tell me what we're going to do with Mr. Payne. I'd like to turn to that if we can. I want to make sure we get through that.
Yes, Judge, we are gonna try to resolve that today.
Okay. Do you have any sense of who your counterpart is from the DA's office for this?
I had sent some emails to Miss Dilligard, so let me see who's on here.
So she, Ms. Nix, I see is here, and the word I got is that Ms. Nix will be filling in for Ms. Dilligard today.
Okay.
Good morning, Judge, or good afternoon.
Hey there.
I believe Mr. Rao is on the call and he is actually handling today's calendar, but if something has changed, I can jump in.
Okay. Let's see, Mr. Rao, are you in a position to try to handle Mr. Payne's cases? That was neither yes nor no.
He's on the add-on calendar, is that correct?
I guess I don't have a piece of paper with his name on it. I know that we met with Mr. Payne recently and got some news that said we could move forward with his cases. So if someone can send me the add-on, I'm happy to do the style of the case. I just recognized Mr. Payne in the booth and wanted to see if we could handle that. And then we turn to Mr. McCaslin just to close the loop and get our friends from Cobb back to their work.
So I will defer to Ms. Nix. I'm not aware of what the terms or any conditions of the plea or non-negotiated or negotiated. So I will let her.
It may just be probation. Ms. Wood, is this just a revocation, or I now have the calendar in front of me and it's a 23 SC case. Is it a probation warrant for that 23 SC case, or is the 23 SC case the basis for the warrant?
No, Judge, you're correct. It's strictly a probation warrant for the 23 SC case.
Great. Then it looks like Ms. Nix, you are it. I'm gonna, while you have a chance to get your breath on that, Ms. Rios, my understanding is you'd like to be in a breakout room with Mr. Finley. Is that right?
Yes, Your Honor.
Okay.
So if it's just the probation warrant, Judge, I can handle that. I just didn't know if there was some sort of discussions as it relates to the indicted case, or if that was even an active indicted case.
No, it's all based on a probation warrant. I don't have that in front of me either, but maybe we can get that and see. I'm trying to find Cobb right now, though, the jail. I don't know that they're on. I have Mr. Finley listed as being in Cobb. And there's lots of Cobb listed here, but it's all lawyers.
And one thing, Your Honor, I tried to have my investigator go see him at Cobb, and they were saying that he wasn't there, so I wasn't sure what was going on with that.
Okay, let's dig a little deeper. I know I've seen Mr. McCaslin. Who is in, Mr. Swinger? Can you wave your hand? All right, that's Mr. Swinger. Got him. And then we've got Mr. McCaslin in 6 South Booth 3. I recognize him. I don't know that Mr. Finley is on. Ms. Nelson, if you don't mind poking around to see about that. Ms. Rios, if we figure out how to get him on, I will get him into a breakout room with you, okay?
Okay, thank you.
All right. And Ms. Nix, did I understand correctly that Mr. Rao is going to cover for you?
Ms. Wood and I are actually trying to discuss, see if we can come up with a resolution. So if we're able to do that, then I'll do it.
Okay. do you have a copy of the Payne warrant?
Yes, sir.
I'll give it back.
Judge, if you need it, I can email it to you.
Nope, I got, Simpson's got it. Thank you. All right. And Ms. Rivers, I'm sorry, I didn't confirm that you were all systems go when we had Ms. Kikendall's bond hearing.
Yes, Judge. Good afternoon. I've been on the record. Yes.
Thank you. I figured you were. You would have said, wait, stop. Ms. Nix, are you okay going on the record with Mr. Payne's situation?
Yes, sir.
Okay, let's do that. Let me get Mr. Payne's audio going to North Booth 3. And thank you to Judge Richardson for giving us her booths today. Take a second. Okay. Hey, Mr. Payne, can you hear us?
Yes, sir. Yes, sir.
Great. Thank you for your patience. We're going to go on the record in your case. It's 23 SC 191912. And Mr. Payne, I signed a probation warrant in your case back in June of last year. The allegation was that in June of last year, you got in a little bit of trouble in Cobb County, that you committed simple battery and disorderly conduct. You also had become a little scarce for probation. You weren't reporting, and you had a drug screen that you missed. So minor violations. The allegations are minor, but still something we needed to work through. You got picked up on that warrant, and then there was a little bit of time when you and I had a little trouble communicating, or actually you were very communicative, but it wasn't leading to a real fruitful conversation. But I think we're in a position to move forward. Ms. Wood, is Mr. Payne, what's the status of his Cobb case, if you know?
Judge, it's my understanding that he has resolved that and just has the probation to deal with now in Cobb County.
He got probation as a result of those charges?
That's my understanding. I think that he maybe did a little bit of time. So, and I'm sure he can clarify for us, but I think he may have, done a couple of months in Cobb County and then came directly to Fulton.
Got it. Mr. Payne, tell me what you remember having happened as a result of your charges in Cobb. Did you plead? Did you get a sentence? What happened there?
I pled guilty.
Okay.
Yeah, I pled guilty to the 3 charges I had.
Do you know if it was misdemeanors or felonies, or does that not mean anything to you?
It did mean, not currently, I guess it does mean something. I think I got like 2 of them were felonies and 1 was a misdemeanor.
Do you remember the sentence you got?
4 years, the 4 years and 51 days, I think, of probation.
Okay. And then you were released in theory, but because you had a hold from us, you didn't actually get out. You got transferred from Cobb to the Fulton jail?
Yes, sir.
Okay. I understand. So Ms. Wood, now that I better understand that, is Mr. Payne admitting to these charges, or what's happening?
Yes, Judge, we'll admit to the arrest and the conviction.
Okay. Let me ask Ms. Simpson a question. How much time remains on Mr. Payne's probation in the 23 SC case?
He has 3 years, 6 months, 4 days, Judge.
All right. And in case you all couldn't hear that, because we don't have a microphone over in the jury box, it's about 3.5 years remaining on the Fulton County case. Ms. Wood, what is it that you are recommending as a result of these violations?
Judge, Mr. Payne is asking the court to revoke 163 days. He's been in since August 8th of last year, and then to be reinstated to probation. He did ask about transferring the Fulton probation to Cobb County. The only hiccup that I foresee with that is that he doesn't have an exact address to give to probation. However, he's indicated to me that he is familiar with the shelters that are available, and he knows that he does need to report a little more often when he doesn't have a stable address on file with probation.
Got it. Okay, I understand that kind of request. Ms. Nix, what's the state think ought to happen in Mr. Payne's case?
Judge, I pulled up the cases from Cobb County. They were misdemeanors, 2 counts of simple battery, which he pled guilty to August 7th of 2024. Looks like he did get probation. So the state's fine with the recommendation of the 163 days and restorative probation. We just asked that he be instructed to, I think as you already said, to update his address and report more when he's doesn't have a stable address. And we asked that he be instructed to report to the day reporting center or probation within 72 hours of his release.
Okay, got it. You said day reporting center. Was that something that was already on Mr. Payne's agenda, or would that be adding a condition?
That was, so I had the petition up, and one of the, violations was that on June 18th, 2024, he failed to report to the Atlanta Day Reporting Center for a substance abuse assessment.
Okay, but that may have, I'm sorry, keep going.
Or as instructed on June 12th. So I know that I was the one that did this plea a couple, 6-7 months ago. And I seem to remember that it was a day reporting center was a requirement, but let me confirm that.
Okay, I'm going to look at the final disposition, but it may well have been that's simply where he was going to take his drug test, is that he would take that at the day reporting center. All right, probation is looking into that right now. I'm looking at your sentence from before, and you were supposed to stay away from Mr. Rice, and then you were going to have a drug and alcohol abuse evaluation, and then whatever the recommendations were. So probation will look into that. Let me tell you what I'm going to do, Mr. Payne, and then we'll sort out the day reporting thing. In light of your violations, the main one was getting arrested and ultimately convicted for those charges in Cobb County. I'm going to revoke 6 months and 4 days so that you'll have exactly 3 years probation left. You're going to get credit for the time you've been in, which is 21 days shy of 6 months and 4 days. It'll be up to the sheriff whether for the remaining couple weeks he gives you 2 for 1, or he may say, you've done so much of that sentence. Oh, wait a minute. I won't do more than 6 months because that could make things complicated. I'm going to revoke you for 6 months exactly. The 4 days just came from what was left on your sentence. So I'm going to revoke you for 6 months. You'll get credit for the 163 days you've done. You'll be back on probation when you get out. And in terms of where you report, I guess, Cobb County misdemeanor probation won't be through the Department of Community Supervision. So you have to report to a different place for that. Do you know where you report, Mr. Payne, for Cobb?
I didn't get any instructions on where to report for probation. I don't know anything about where I'm supposed to report for probation in Cobb County. I don't know.
Okay. All right. Well, maybe Ms. Wood can help you with that. Oh, that's a Cobb County thing. You'll certainly get directions from us. And to your request, I was going to say, well, let's have it be in Cobb, but I don't know that it will work that way until you establish that the shelter you're in or the house you're in, wherever you end up staying, is in Cobb, because of course this case was in Fulton, but I'm going to let probation tell me about that. But based on your violations, that's what I'm going to do. And then just like Ms. Nix said, I'm going to encourage you to stay as plugged in as you can with felony probation. And that means every so often you poke your head in that office. Hey, I'm here. It's Mr. Payne. And everything's doing okay. If you get hard to find, then they're going to come back to me with another warrant saying, we don't know if Mr. Payne is safe or what's going on. So you just need to make that a project. And that's not every day. That's not every week. But it is every so often. If you don't have a way to call, that you show up and say, I'm just checking in. Does that seem fair to you?
It seems fair. Yes, sir.
Okay. What do we have to say, Ms. Simpson, about one, Was the day reporting center something that got added because of the evaluation? Please.
Assistant Chief Sadler. From what I'm seeing, he tested positive, which led them to bringing him for a substance. Well, he was supposed to do a substance abuse evaluation. And on May 22nd, he tested. I'm sorry, Your Honor. He was going there for drug screens.
Okay.
Because he was attending substance counseling. And that was his reasoning for going to the drug court.
Okay, so it wasn't that he was formally in the day reporting center, but his drug counseling and his UAs you actually went to the day reporting center simply because that was the location for those services.
And he was doing the substance abuse assessment there.
Okay, which didn't happen. That's the thing that he skipped, which was another basis for the warrant. Okay, all right. Well, you're gonna need to have that assessment. What about reporting? Mr. Payne right now is unhoused. He'll get out. And it sounds like he'd like the center of gravity in his life to be in Cobb, but he doesn't have an address there yet.
If he does not have an address in Cobb County,
Yep.
and he doesn't have a felony case in Cobb County, we won't be able to transfer that case there.
Okay.
Without having an address. However, he is currently being supervised by Officer Burgess, so he will be getting reporting instructions to report back to his previous officer.
Okay, great. As long as that can be I don't know that Mr. Payne necessarily has a phone to call Officer Burgess. It may need to be, let's meet at DCS or whatever. Okay.
And we can do that. Being that he's homeless, he'll need to report to Officer Burgess.
Okay. Makes sense. All right. So we just talked a lot, Mr. Payne, about your probation situation. I don't know if you could hear Chief Sadler because there's not a microphone there. But until you get an address, and again, it can be a shelter in Cobb, you're going to need to report in Fulton. I know that's not your preference, but that's how it needs to be at first. So you're going to get out in the next week or two, and you can try to find a place in Cobb. And once you can document that, get a piece of paper saying he's a resident here, then probation is happy transferring things to Cobb. But until something like that happens, you're going to need to plug in with the probation office down here, which is a couple blocks from the courthouse. Okay?
Okay.
All right. What reporting instructions should we give him? Do you mind, just so he can hear? Either one of you can just borrow that microphone right there. You know what? Ms. Wood can write it down and then she can figure out a way to get it to him.
Like we did with a previous client of ours.
Great. If you'll just bend that microphone down so they can hear you. It's not going to break. Don't worry. Bring it on down. There you go.
Okay. Can you hear me, Mr. Payne?
Yes, ma'am. Yes, ma'am.
So you're going to report to the Atlanta office at 276 Memorial Drive. That's going to be Atlanta, Georgia 30303. And you're going to report. You must report within 48 hours from your release.
Okay.
Ms. Wood, I will send all the contact information and his reporting instructions to the email that we have been corresponding before.
Thank you. I appreciate that.
No problem.
So, Mr. Payne, we're about done. I just want to remind you, I know you're saying you got it, but it's important. You're going to get out in the next week or so. When you get out, within 2 days, you might as well just do it right away, but within a couple days, you got to report to probation and connect with those folks, or they're going to take out another one of these warrants and we go through this process again, okay?
Okay. All right.
Any questions about that?
Yes, sir.
All right, Ms. Wood, anything else on behalf of Mr. Payne?
No, Your Honor. Thank you.
Ms. Nix?
No, sir.
All right, thank you. Mr. Payne, you are free to leave that booth. Thank you for your time.
All right, thank you.
All right, let's figure out, do you need the warrant back? So you can have it.
We have a copy.
It's for me.
You need to keep it.
I don't know. I don't need it. That's why I was happy to give it back, but I can recycle it if you don't need it back.
You have a copy.
Done. Okay.
He was getting credit for the time that he's already served, which was from what date? Or just do this, you put those days?
No. You're using the new form. We met with XO and Chief Lane yesterday.
Yeah, we haven't had training on it.
No, I know. It just dropped out of the sky. But Judge Ingram was using the new form, and in theory, we should use the new form. But regardless of what form you use, the answer to your question is he should get credit from August 8th, 8/8/24.
Okay.
That's the 163 days Ms. Wood had come up with. All right. Ms. Nelson was saying that Cobb was out there, but I don't have a waiting room. It's you get to just bust on in if you have the Zoom link. We'll keep working on that. All right, Mr. Cazzoli, are you ready to talk about Mr. McCaslin? Because I don't want to keep our friends from Cobb stuck on here any longer.
Yes, Your Honor. Good afternoon.
Good afternoon. Let me get you on the screen and Ms. McCauley back on the screen and Mr. McCaslin, and we got to unmute him. 6 South Booth 3. All right, Mr. McCaslin, can you hear us?
Yes, sir.
Great. So let's go on the record in your case, which is 24 PI 008684. You're co-defendant with Ms. Kikendall, and you already had a bond hearing, and yet here we are again. So I don't typically have a follow-up bond hearing unless there has been a material change in the case. Arguably, there's been one. There's a different prosecuting agency, but that doesn't necessarily change the charges or the procedural posture. So I want to start with you, Mr. Cazzoli, to tell me, other than you are a persistent lawyer, if there is something new and different about Mr. McCaslin's case that prompted you to file the bond motion, because it was enough to get Ms. Nelson to put it on a calendar, although it might have been simply because we're going to be talking about the case. Ms. Kikendall never had a bond hearing. You thought, well, I want another bite at the apple.
Yes, Your Honor, and I appreciate you giving us the opportunity to talk about this case today. I think at our last bond hearing, if I'm remembering correctly, it was either exactly a day or perhaps exactly 2 days before his preliminary hearing. At the end of his bond hearing, I think, Your Honor, you had acknowledged that his case, even just based off of the facts that you were aware of, was different than some of the other very similar it was different than the cases that have that same charge, just kind of by virtue of the facts that were available to you at the time. That became more apparent, Your Honor, and officially put on the record at the preliminary hearing. First-degree murder was dropped as a charge. Felony murder was found to be non-applicable, and he was officially, it was the charge that was bound over instead was murder in the second degree, Your Honor, specifically the carve-out for death resulting from a criminal negligence for child cruelty. Furthermore, Your Honor, another charge that he originally had was possession of Schedule 1 or 2 drugs with intent to distribute. That charge was dismissed on the merits at the preliminary hearing as well.
That's more than enough for us to be talking again. And I am remembering, I think you or one of your colleagues helped me understand, like, you know what, these bond hearings in some ways are happening too soon. We would prefer to have the prelim first, because then we could have had the conversation we're having right now about what's the true lay of the land after a magistrate has heard some under oath evidence about the charges. So I understand why we're meeting again, and you should share with me what you want about Mr. McCaslin, and then I'll hear from Ms. McCauley.
Absolutely, Your Honor. Thank you. Your Honor, I
as much of the facts, I suppose, as you're willing to hear, or whatever is going to be most pleasing to the court in regards of what was discussed at the preliminary hearing. I think that going into just kind of what was hinted at based off of what was in the warrant and what was discussed, even just minimally at the last bond hearing, a lot of assertions were made by the state about what the evidence they had was going to be able to show. At the preliminary hearing, that was the state's posture as well. The witness did describe a lot of the facts that are in the warrant. Specifically, though, Your Honor, what we found was that there was no evidence, one, of the alleged drugs being actually in that room. If there is evidence to that, Your Honor, it was not testified to at the hearing. There is certainly the allegation that that is where the drugs were found, but at the preliminary hearing, Your Honor, there was testimony by the witness, I believe multiple witnesses, showing, Your Honor, that they had no evidence that the methamphetamine and crack cocaine, Your Honor, alleged to have been in the blood of the deceased child was actually found in the motel room itself that was occupied by Mr. McCaslin.
So, based on the charges that remain, and I don't mean to be flip, so what? I mean, does it matter where drugs were found? They were there. It sounds like there's evidence that they were found in the child. And so someone either put them in the child or left them somewhere where the child could get them. And either of those scenarios, one, are alarming. Either one is alarming, but two, support the charges that I guess Judge Brooks did bind over and find probable cause for. So I may just be misremembering something. Let's say when all is said and done, the state doesn't advance at trial an argument that the drugs were in the hotel room. They were in the car, or they were in a backpack to which the kid had access at the godmother's house, or who knows what. Tell me why that's important, other than, and this is important, a very clear, grim picture was painted at the first bond hearing that basically this hotel room looked like a candy shop full of different types of drugs where this kid could just walk around or toddle around and grab at the drugs. And maybe that wasn't the place where the drugs were that ended up fatally inside the child.
Absolutely, Your Honor. And I'm happy to kind of continue on that route of thinking as well. One of the other assertions made by the state was that Mr. McCaslin was caught either in a lie or misremembering the fact that there was that he had taken the child outside throughout the day multiple times. That was again presented as fact that he had said this, and there was no evidence of this. That was presented by the state as evidence of a lie or misremembering by camera footage showing Mr. McCaslin leaving the apartment multiple times without the child. One thing that did end up being brought up unsuccessfully to deny probable cause, Your Honor, because again, the circumstantial evidence, we're not arguing that things should be dismissed at this stage. We're just kind of arguing for the context here. One thing that was acknowledged by the state, acknowledged by the witness, was that this was a very specific camera angle, not showing the door that could open or close, but instead showed only one direction down a hallway.
Right.
So every time Mr. McCaslin or anybody was walking that direction, it is correct that there is no video footage of Mr. McCaslin taking his child outside of the motel room. But that does not mean that he did not take it out. There's nothing specific showing that that he did not take the child outside. He just didn't happen to go down that direction of the hallway. And both of those, Your Honor, kind of coincide in that there's a very specific portrait being painted here by the state for these charges. It is that regardless of whether it happened exactly in the hotel room or handed to the baby outside or handed to the baby at some other point, that this was something that was in possession or at least control of my client, and that ended up being ingested by the child. And based off what Mr. McCaslin has been saying this entire time, and this is both recorded in the warrant, I believe, as well as I heard testimony that this was part of Mr. McCaslin's initial statement to investigators, is that the baby was outside and he did not have those drugs in the home. He does not know where those drugs could have come from, but that the baby was playing outside in this motel. And so if this was an incidental ingesting, that is something that is wholly within possibility based off the facts that we have been established Again, if it's possible that the state has other facts that I have not heard, but based off what was established at that preliminary hearing, that is all still much within the realm of possibility. And I don't think the state, a different agent of the state at the time, I don't think that was part of the picture being painted by the state the last time we had this hearing, Your Honor. So we do think it's a very important fact that was established at the preliminary hearing, that there was no evidence of these drugs being found both in the motel room, and especially, Your Honor, we think it's really important that just because they didn't see Mr. McCaslin going outside with that child during that day, they were relying on a very specific camera angle that would have only showed Mr. Caslin leaving the apartment with the child and taking a right. If he had left the apartment and taken a left, which was possible, we looked at a diagram, or not a diagram, but a full photo of what this looks like. There was another staircase on the left side. If he had taken a left with that child, he could have gone outside. So, Your Honor, I think that one of the reasons that that information is important here is that it does bring some doubt to how certain the state is that Mr. McCaslin is responsible for the death of this child. And Your Honor, I think that another thing that we saw in the video, which again is very consistent with what Mr. McCaslin told investigators immediately on, is the first time we see Mr. McCaslin with the baby is about 5 minutes before the 911 call is made. And as Mr. McCaslin frantically running up and down the hallway, this time you do see that on camera, with this baby calling for help. And then about 5 minutes later, you see him frantically running up and down the hallway on the phone. And we were able to determine that based off the timestamp, although it was off by a couple minutes, Your Honor, I'm not sure whose error that is consistent with when the witness admitted that was probably consistent with when he was frantically calling 911, asking for emergency help to come for his baby. I'm also, Your Honor, happy to, there are a few changes to Mr. McCaslin's potential living situation. I'm happy to go back over as well. I just kind of wanted to bring the reason that we filed so quickly back to your attention.
Okay, and you've done that effectively. Thank you. It sounds like it's a significantly different landscape. In some ways, we still have a child who died from overdosing on drugs, who was under the supervision of the two people charged. I want to make sure I follow the significance of this camera only shows one direction, and it did not show Mr. McCaslin carrying the child before the crisis occurred. You're sharing that with me not because it's particularly significant to were there drugs in the apartment or not. It's that it corroborates something Mr. McCaslin said, or put differently, it doesn't disprove what he said, whereas maybe what had been represented in court by different people was that the video footage shows that it was impossible for him to have taken the kid out because it shows he never had the kid in his arms. And you simply learned through the preliminary hearing that actually he could have. It's just with kid, he always turned left, and with no kid, he always turned right. It's not, that's important, but it's not any more profound than that. Is that a fair summary?
Yes, Your Honor. I think what had kind of been asserted by the state at the time is we have video of him leaving the motel, and he claims that the kid was outside, and we don't see that there.
Shows that it didn't happen. Okay, that he was lying, and this is, it could be that he was being truthful. Got it. Please do update me. You heard when I was interacting with Ms. Steffo the kinds of concerns I have about someone being out, and I'll be honest, I don't remember anything about Mr. McCaslin's criminal history, if he even has one. So I'll get that from Ms. Smith-Mann in just a minute. But you tell me what you've been able to structure should a bond be set for Mr. McCaslin.
Thank you, Your Honor. And some of this is, unfortunately, I've been unable to follow up on this independently. I spoke with Mr. McCaslin and got new information yesterday when I visited him at the jail. So some of this is still going to be a bit in flux, but I'll make sure I highlight those parts of it. Your Honor, Mr. McCaslin is 34. He's been living in Georgia his entire life. He was specifically residing in the Metro Atlanta area for the last 4 years. I know, Your Honor, I had mentioned in our initial bond hearing that he's been working for Alexandra Property Group doing maintenance for them. I learned yesterday a few more details about that. He's actually been working for them for 14 years. So this is not just a job he happened to have upon arrest. This is a job that he believes he can go back to. He's been working there for quite some time. He has really strong ties to the community, specifically through this work as well. Your Honor, I think we mentioned previously that he has other children beyond the deceased child, one that he shares with his co-defendant that was previously mentioned that will be living with the godmother. He also has 4 other children that are each with their mothers right now, but when he's outside of jail, he does have split custody with them. He's I wasn't able to get the exact breakdown of how many days for each child, but it's quite frequent. When they're not in school, he's with him. They're with him. When they are in school, they're typically with their mothers. Your Honor, I know that, again, I'm happy to wait and make further comments after hearing a new recitation of his history. My understanding, Your Honor, is that he has an FOA from 2010, first offender from 2010 for burglary, but no other felony convictions or similar convictions, Your Honor, and he has nothing else similar to this. No violent charges. I don't recall if there are even any drug possession charges, even misdemeanor drug possession charges in his history. But again, I will defer to both the recitation as well as Ms. McCauley's understanding of the facts as well. I do want to highlight, Your Honor, I know that this was commented. I guess I've heard about this situation at every single hearing we've had so far, that July THC issue with the child. My understanding, Your Honor, is that there were no charges ever came from that. There was nothing that was determined. And again, I could be incorrect about that, but my understanding is that no charges came from that, and that it was deemed an accident at the time. Lastly, Your Honor, I just want to make sure that I'm able to hit everything.
Have part of your lastly be whatever you're going to tell me about where Mr. McCaslin would stay.
Yes, Your Honor, that's exactly where I was headed with that.
Okay.
So, Your Honor, his most recent address was that motel room. He'd been living there for quite some time, both due to my advice as well as kind of the fickle nature of living at a motel. That's not going to be something he's going to be returning to. Instead, Your Honor, he does have 2 options about where to live. This was what I brought up earlier about not being able to confirm addresses at the time, but his father and his sister have offered him availability to stay with them at least for the foreseeable future until this case gets resolved. I have not been able to get those exact addresses, but as part of our eventual bond ask, Your Honor, we would have absolutely no issue with release being dependent on provision of those addresses.
Got it. Can you, Mr. McCaslin, before I hear from others, your father lives in what town, if that's where you were going to be?
DeKalb County.
Okay. And your sister?
Cobb County.
Okay. Thank you. Anything, Mr. Cazzoli, I'll come back to you at the end. Anything before I turn to Ms. Smith-Mann and then to Ms. McCauley?
Yes, Your Honor. Well, actually, I'll go ahead and defer to both of them if I am given the opportunity to have the last word. Thank you.
You will. All right. Ms. Smith-Mann, what can you tell me about Mr. McCaslin's criminal history? You're on mute.
I am so sorry, and I was given that history. It appears the defendant has an open case pending in Fulton County for theft by receiving stolen property, 24 PI 003210. His last arrest was on 6/11/2024 for driving while license was suspended or revoked. There are 13 prior cycles. It looks like there are 2 misdemeanor convictions. There are no felony convictions. There is the 1210 burglary that was mentioned as first offenders. It was, however, sealed on November the 17th. There's nothing further, Your Honor.
Great. Thank you so much. Let me look one thing up before I hear from Ms. McCauley. Okay, I was just looking up this other case, which involves a stolen Fannin County Sheriff's Office firearm. All right, Ms. McCauley, please.
Judge, just to go over briefly the facts, I did not have the benefit of handling the preliminary hearing. However, I am intimately familiar with the facts. I'm sure Mr. Defense Counsel has not had the pleasure of going through all the discovery that the state has at this point regarding some of the facts at issue and issues that he raised. I'm just going to start, Judge, with highlighting some of those text messages that actually provided to the court. I also sent them to defense counsel so he would have the benefit of reviewing those as well. Relating to the July 19th incident that was framed as an accident, I don't know if it's an accident to let THC be just lying around within a child's reach, but it was actually Mr. McCaslin, along with his co-defendant, who's listed as Sue wife in the defendant's phone and pictured on these text messages. That was the one who said never admit anything to DFACS.
The date, I'm gonna interrupt you for a sec. You said the July incident. That's July 2024.
That's July 2024. That's the first overdose of this particular child.
Okay, but it's not July 23 or 22. It's relatively close in time to the fatal overdose.
Yes, it was July of 2024.
Okay.
Co-defendant text, are you sure about the blues? If the court is not aware, the blues is street terminology for THC. This defendant responds, sure. He was with me and the other kids outside when he started acting different. You don't smoke or do anything drugs when they ask you. Co-defendant responds, what if they want to test me? He responds, never admit doing drugs, period, to DFACS. That is on July 19th. That's the first overdose. So that's just to illustrate the defendants were well aware of what their child had ingested, and I don't believe that it was an accident. As it relates to the October 25th, 2024 fatal overdose of the methamphetamine and the cocaine of the child, certainly the court can read through the text messages that were submitted. But prior on that day, there are a number of transactions that are noted in just reviewing these text messages, including the buying and selling of firearms that are on the 25th. And if the court reviews also the co-defendant's text messages and reads those together, it's pretty obvious that both of these defendants were heavily involved in drug and narcotics sales and trafficking, along with firearms trafficking. And just to comment on where this defendant was when the child ingested the fatal narcotics, methamphetamine and cocaine, as the court is well aware, those are not substances that are just left at the door or left outside for a child to just ingest randomly, but frequently held and kept in a hotel room that is occupied by two drug traffickers who are making their income off of selling drugs. And that is how this child ingested the fatal narcotics that resulted in his death. I'm sure that defense counsel is also not apprised of the two hand-to-hand transactions that were video recorded by College Park Police Department that transpired in the summer of 2024 into the fall of 2024. Those drugs have been submitted to the GBI, and it is the state's intent to include those on the indictment when we move forward to reach that threshold in Eubanks v. State, which is the case involving the heroin dealer that where a child got access to that heroin and died as a result. That's a 2023. I have a citation for the court's information, but it's not necessarily relevant to the purpose that we're here today, which is to discuss bond. But as it relates to the defendant's danger to the community, certainly his drug activity, as illustrated in both the text messages, as well as the facts and circumstances involving this child's death, indicate that he poses a significant risk to the community. As it relates to his willingness to follow the law and return to court, I think his criminal history speaks volumes of that. I'll begin with his first conviction for possession of marijuana out of Fulton County from April of 2010. That was a misdemeanor. Its time expired, is listed on his GCIC. In November of 2010, he had that conviction for burglary and possession of tools, which was correctly sealed under first offender, served a 2-year probationary sentence on that. He had a September 2015 family violence arrest that his time expired, also out of Fulton County. He had a June 2016 possession of a firearm by first offender that was dismissed. He had a March 2017 driving on a suspended license and license plate violation out of Gwinnett County that he pled NOLO to in January of 2018. Then he had a March 2017 arrest for hit and run out of Gwinnett County, pled NOLO on May 2nd of 2017. He had a false arrest for false name in January of 2018. That was null prost out of, I believe, Fulton County in April of 2018. And then moving into, he had a January of 2018 failure to appear and probation violation out of Gwinnett, September 2018 driving on a suspended license, April 2019 probation violation, arrest May 6th of 2024 for theft by receiving. It's the state's understanding that that case is still open. So multiple probation violations, multiple failure to appear, demonstrates a clear unwillingness to adhere to the rules of the court and appear for court when called to court, as well as a risk of flight from the jurisdiction. So based on the totality, Your Honor, the state would request that the court deny bond and that Mr. McCaslin remain in custody. Also, as to the change in circumstances, which the court briefly addressed with defense counsel, the defendant is still charged with murder, and he's still charged with the murder of a child and the death of a child. So it is not necessarily a significant change in circumstances that a magistrate court judge heard some evidence, perhaps not all evidence, and dismissed some of the charges. It does not change the nature of the arrest, which is the criminal negligent homicide of a child that was in the defendant's custody for something that is, one, completely avoidable because it's illegal activity, but second, completely avoidable to keep narcotics away from a child, particularly a child that has a previous overdose. So on that basis, Your Honor, we would request that the court deny bond.
Understood. Thank you. Mr. Cazzoli, as promised, this is your chance to share anything in response to that or anything else that came to mind while you were hearing from Ms. Smith-Mann and from Ms. McCauley.
Thank you, Your Honor. Your Honor, the evidence discussed by Ms. McCauley and the discussion of what the underlying facts are, especially considering the history, Your Honor, are not so different from the assertions that were made initially at Mr. McCaslin's first bond hearing. I do think because she references the text messages quite a few times, I understand that the rules of evidence are quite different when it comes to a bond hearing, and your appraisal of those text messages, Your Honor, are in the context of bond and not in the context of what is proper evidence. I do think it's relevant and important to note at the preliminary hearing, those text messages were not allowed in. They were determined by Judge Brooks to be irrelevant. There was no mention of specific drug dealing by my client within even a reasonable time frame. I think it was multiple months. And Your Honor, this is not we're not making an argument, Your Honor, that Mr. McCaslin has never used drugs. We're not making an argument that he has never dealt drugs. I don't know that. This is the only case I represent Mr. McCaslin in. However, Your Honor, the evidence provided by the state at the preliminary hearing did not have enough to show probable cause that he was doing it that day. That charge was there, and it was dismissed. So I do think it's important, Your Honor, and this actually reminds me of another thing that the state had asserted at the time, trying to show that Mr. McCaslin was being untruthful, is that they made the argument that he had denied selling drugs, when the witness was actually was testifying and was cross-examined, she admitted that the only evidence they had the witness admitted that the statement made by Mr. McCaslin is that he had not sold drugs for a long time, and that the most recent evidence that they had that he had sold drugs was from multiple months previous. So nothing within the time frame of the incident itself, based again on the evidence provided at the preliminary hearing. Your Honor, in terms of the change of circumstances, we understand that the charge, that a child is still deceased. That is not a fact that we expected to have changed between the last hearing and this hearing. But we do think, Your Honor, it's important that this is not something now, because murder means a lot of things. Murder means it can mean malice, it can mean intent. But the fact that this was now downgraded from murder 1 and potential felony murder to now a murder 2, Your Honor, that is a distinction. It's a clarifying distinction about what is alleged to have happened. So we do think, Your Honor, that circumstances have changed, especially considering the dropped drug charges as well. The circumstances have changed over the last thing, Your Honor, is our actual request here. Considering this change in circumstances, considering the evidence that either has come to light or has failed to come to light based off the assertions of the state, we believe, Your Honor, that Mr. McCaslin is a good candidate for bond. The felony that was mentioned, a first offenders, it was taken when I was in 10th grade. The misdemeanors that were referenced, Your Honor, the last thing was 2018, an FTA in 2018. So this is now 6 going on 7 years of no alleged criminal activity. So it's our position, Your Honor, that Mr. McCaslin is a good candidate for bond. He's had nothing like this in his past. His last drug offense, again, 2010. Our request is a $50,000 bond. We're asking for $40,000 on the murder 2 charge and $10,000 the cruelty to children charge, Your Honor. Nothing further.
Okay, thank you, sir. I appreciate your observation that there are some things that have changed, and you've referred to them as changed circumstances, maybe because that's how I started this. And like, why are we talking about bond again? And you've highlighted some things that have changed. I'll call it procedurally. There was a hearing in which Ms. McCauley did not participate, where a magistrate judge made certain decisions that have consequences. And one of the consequences is it's appropriate for us to be talking about this again. What I see are some peripheral charges have for now gone away. Doesn't mean that they won't be in the indictment. But the core situation is still the death of a minor who was in the care, custody, and control and is the biological child of your client and Ms. Stefo's client. And it comes on the heels of what should have been the most significant wake-up call a parent could get, and that would have been the July incident, which of course comes on the heels of your client having been arrested for having a firearm stolen, not just from someone, but from law enforcement. Not saying he took it. His story to the police, I looked at the warrant, was I bought it from some dude. And so maybe he didn't know it was from a sheriff's office. But actually that arrest undercuts your claim that it's been years and years since Mr. McCaslin had been in trouble. It's just an arrest and it's a pending charge, but it's not ignorable. So what I see here is a landscape that has improved procedurally for Mr. McCaslin. Right now, the charges that are pending in this case, not the gun charge, but in this case, are less serious in terms of what the possible penalties could be, perhaps. But they remain as powerfully concerning because of the underlying allegations. And I don't see a change in circumstances in my ability to keep the kids safe if Mr. McCaslin is out, to keep Mr. McCaslin out of trouble, and to ensure that he would come to court. I will look at the text messages. If in looking at them, I feel like they have been materially misrepresented to me, they're aged, it's not clear that they're his, they're not germane in any way. Really what they need to be is almost exculpatory or painting a different picture than what I understand this case to be about. I will certainly let both sides know. We may need to have another conversation, but right now I intend to leave Mr. McCaslin's situation unchanged. As he probably heard me say, Ms. Kikendall, regardless of what I do here and now, should this case be indicted, there will likely be a different judge who gets the indicted case, and you won't follow the case, Mr. Cazzoli, but there will be another public defender who will very ably represent Mr. McCaslin, and that person will be free to have this new judge, new meaning different judge, look at the facts and circumstances and decide if bond is appropriate then, once there's the charging document in the form of an indictment. So that's where I come down right now. Of course, if we get to day 91 and there's not an indictment, I expect you to be banging on my door, Mr. Cazzoli, and I will not be saying, wait, why are you back? You'll just need to say 91. That'll need to be the only thing you say, and I'll understand why we're talking, because it will be time then to set a bond with conditions that go as close as I think we can get to making sure that everyone will be safe and everyone will show up to court and no one's going to get arrested for driving with a suspended license or hit and run or having a gun he shouldn't have. So that's where we end on that one. I appreciate, Mr. Cazzoli, you being persistent and effective as an advocate for Mr. McCaslin. And again, Ms. McCauley, I appreciate your office taking this case for our office. And we will reconvene if I'm called upon. Otherwise, it will be Judge X to whom the indictment is assigned. Thank you.
Understood, Your Honor. Thank you very much for hearing our argument.
You bet. Ms. McCauley, thank you. I will look at those text messages and get word back to you and Ms. Steffo as to Ms. Kikendall.
Thank you so much, Judge.
You bet. Bye-bye.
Bye.
Mr. McCaslin, you are free to leave the booth if that's what you want to do. Thank you, Mr. Cazzola. You're free to go.
Thank you, Your Honor.
All right, Ms. Rios, I feel bad if you have been on just for Mr.
Yeah, and we had an agreement. I mean, it's only 3 months and he's done 3 months. And this would have been quick, but
I'm sure it would be. You are always efficient and on it, but I don't see a Mr. Finley. So we need to figure out where he is. I will offer this up, number one. If we can track him down real soon, maybe I can get a colleague to cover it next week. I am going to be at the annual winter judges training, so I can learn more about the law and try to do a better job at what I do. But number two, if for some reason we can't pull that together, because it's always hard to get a judge to cover something like this, there's no reason why. Let me see what I'm not committing Ms. Nelson to this. Let's be clear, but as early as that Monday when I'm back, I've got some civil stuff in the morning. But if it's quick, we could just make it happen on Monday, borrow a Zoom slot from someone or a transport slot. I don't mean to drag this out, but I know Ms. Nelson has been trying to figure out where Mr. Finley is or where the Cobb County Jail is. And we know physically where it is, why they're not on the Zoom, but we've been stuck.
okay, no worries. Whenever y'all find him, I will get on Zoom.
Okay, well, I mean, if you find him, that would be good. You just told me you don't think he's at the Cobb County Jail.
Well, it said outsourced to Cobb, and then I had my investigator go out there, and they said he wasn't there. So I don't know where he is.
Okay, well, we will collectively search for Mr. Finley and figure out a way to get you and Ms. Nix or Ms. Dilligard on. And I'm fine with it being Zoom. And we have one more matter to work through, so maybe he'll pop up between now and then.
Hey, Jen. So Mr. Finley is the one that's housed at Cobb. They were trying to get connected, and I gave him the information to go ahead and log in from a cell phone. So
okay,
that's what they're trying to do now.
Fantastic. We'll take a cell phone. That'll work. I love the creativity. In the meantime, let's get Mr. Swinger on the screen and see what we can do with his situation. So we'll spotlight him. Ms. Rios, your case, or is that Ms. Woods?
He's mine, Judge. Ms. Wood.
Ms. Wood. All right, let's get her there. And Mr. Swinger is on for a revocation. I do have his 2 warrants. So who's handling this for the state?
I am, Judge.
Mr. Rao asserts himself, and then let's unmute Mr. Swinger, 3 South Booth 3.
And Judge, I am asking for a reset, and I'm happy to explain when appropriate.
Uh-oh, does Mr. Swinger know that?
Yes, Judge.
Okay, good. Hey, Mr. Swinger, I've unmuted. Can you hear us?
Yes, sir.
Thank you for your patience. I know we've been working through some longer ones. But we don't even need to get on the record at first. Let's figure out what we're going to do with your case. I'm going to let Ms. Wood get us started, and then we'll figure out what we're going to do today. If we're not finishing things today, you've got my commitment that we'll get you back here soon. In person, if that's the kind of calendar we have, or virtually, if it's a Zoom day for us. Ms. Wood.
Thank you, Judge. I am asking the court to consider a 60-day reset. He does have probation revocations for both of the cases on the calendar. In addition to that, he has 3 new unindicted cases. I'm happy to share the case numbers. Judge, I've actually already reached out to Ms. Ross, so he is on her radar. I think this might be a good one for drug court. And my only issue right now is I don't think he has enough time left on the revocation. So that's why I reached out to the pre-indictment attorney for the new cases. I'm trying to get those assigned to me because I think if we can work out a plea on those three, drug court might be the best option for him. But Mr. Ross is plugged in as well.
Got it. And now that I'm looking at the warrants again, I read them this morning when I printed them out. We got allegedly back to back to back in the span of 1 week, burglary in the second degree. And then we've got a positive for cocaine that has all the hallmarks of someone who would definitely benefit from being in accountability court. But that's partly a decision Mr. Swinger needs to make that he wants to do. Can't do that today because we got these unindicted cases. They're all in Fulton, which is good. It means we can wrap our arms around them and make something happen with them. And I appreciate you, Ms. Wood, saying, I'm going to try to corral them. And then we could see they're all accusable. Do you want to reach out to, and maybe you've already done this, the accountability court intake team, or is Ms. Ross going to do that?
I think when I spoke with Ms. Ross earlier this week, I think she was going to do that, but I'm going to circle back next week with her. But yes, we're going to get that ball rolling.
Okay. Mr. Swinger, do you know what drug court is? Have you ever heard of that?
I've heard about it, sir.
Okay. Have you heard good things or bad things?
It's good things because it gets you on the right state of mind.
Definitely does. It can do that. It's a partnership. It's not just drug court sprinkle something on you and you're all better. You got to invest in it. But it is certainly an opportunity that might work for you. But what that means is that someone may come by the jail to interview you. They are not a prosecutor. They're not looking to get you to admit and then, you're in lots of trouble. But they're going to ask you personal questions about whether you are struggling with addiction. Do you use drugs? How long have you used drugs? All that kind of stuff. And you want to be real honest with them. If you don't use drugs, don't say I use drugs, because we'll figure that out real quickly and drug court doesn't work. If you do use them, be honest about how bad it is. It's been 30 years. I snort every day, or I inject, or this or that, because it helps the intake team figure out whether drug court would be something that would be helpful. If it's not going to be helpful, we don't want to waste your time in it. But it may well be something that would be a good support system for you. And so my recommendation to you, but it's your call, I won't be there with you, is that when the intake person comes, you be as open as you can with them. It's personal stuff. You say, it's none of your business. Well, it is their business if they're going to try to help you with drug court. So please do engage with them. If you are a good fit with drug court, they will let Ms. Wood know, and then that'll give her something to take to the prosecutor on your cases to say, we're not saying give Mr. Swinger a hug and let him go. It's let's get him in a drug court where it's called accountability court for a reason. If you get in, there is an opportunity for you to thrive and get job training, get sobriety, etc. But if you blow it and just keep getting high and eventually get terminated, that's the accountability part, because there'll be some probation associated with it. And we'll get you another form of treatment that you don't get to walk away from, where it's in custody treatment. And that's less fun and oftentimes less effective because it's not coupled with you getting a job and supportive housing and things like that. But that's a ways down the road. I don't want us to get way out ahead of things. Do you have any questions about what the next steps may be for you, Mr. Swinger?
Really, try to get me a GED and then clean up my act, because really I am tired. I'm tired of coming home. I'm tired of just being a nuisance on myself and my parents, because I sleep with my mother.
Well, you're saying the things that are often a sign that drug court would be a real good fit. It's when the individual is tired of that cycle of, I get arrested, I get out, things are okay for a little bit, and then it goes downhill and I get arrested again, and enough. Okay, we'll do just that, Ms. Wood. We'll set this out a ways because you do have to get a hold of 3 unindicted cases and a prosecutor who will work with you on that. I suspect Ms. Dilligard will. And then we'll get Mr. Swinger back in here. And that may happen a whole lot sooner than the calendar date we get from Ms. Nelson. And if it does, then just, the routine, let us know and we'll get Mr. Swinger and you in and we'll make stuff happen. How much time is left on Mr. Swinger's 2 cases?
Both cases have 1 year, 7 months, and one case is 15 days and another case is 24 days.
It's weird that they're 8 days apart, but either way, that's less time than drug court would work. So Ms. Wood's exactly right. The state would require a plea at least to one of those cases so we can add a little more probation time to make sure you get all the way through drug court. I like the plan. Mr. Rao, you've done a lot on this case. I appreciate it. Anything you want to add? Okay. Ms. Wood, anything else on behalf of Mr. Swinger?
No, Your Honor, thank you.
Mr. Swinger, I will see you again either because we've learned, unfortunately, drug court's not going to work, and we got to figure out what else, or drug court is going to work, and Ms. Wood has figured out a way to resolve your 3 burglary cases. Okay?
Yes, sir.
All right. Appreciate your time. You are free to leave the booth.
All right. Thank you.
Bye.
Thank you, Judge. May I be excused?
Yes, ma'am.
Thank you. Have a good weekend.
You too. Enjoy the attic. All right. Let's see. I don't see a cell phone. Ms. Alexander, you have any update from Cobb?
Yes, sir. I just actually got off the phone with them. They have the meeting ID and he's putting it in now.
Okay. All right. Real time. We're going to catch it. All right. And Ms. Rios, when he gets on, do you still need a breakout?
I think so, only because I have to, I'm not sure if anyone has read the warrant to him.
I'm happy to read it to him. I'm just worried if we get him connected, I guess moving in a breakout room doesn't disconnect anything. So we'll do that. It'll just give you a chance to chat with him.
Yeah, I mean, I don't know if it's inappropriate to ask him if he is okay with stipulating to the fact that there was another arrest. And if he's fine with that, then we can move forward.
I'll put you in a break. Have you had a chance to talk with him, or that's part of the issue because
the issue is I've never talked to him.
Okay. Then it makes sense to get you guys in a breakout room. And I think that's it. Does anyone else have any other cases for today? Oh, okay. Then we'll sit tight for a second.
Hello, Your Honor.
Hello.
Hey, Your Honor.
Hey.
Hey, this is Lieutenant McDaniel with the Sheriff's Office.
Yes, sir.
Okay, I've got Mr. Michael Finney stepping here. I had to get you on the phone because the Zoom cameras and stuff are not working up here in Cobb.
Yeah, I'm sorry about that. I very much appreciate that you are letting us use a phone and connecting that way. Have you all alerted IT? I think it's our IT, not Cobb's IT, that we've got a hiccup.
Yeah, I told Sergeant Johnson, who's at the jail. I told her about it.
Okay.
Yes, sir.
Mr. Finley,
in front of you right now.
Okay, Mr. Finley, can you hear me?
Yes, sir. How you doing?
I'm doing all right. I'm going to move you into a breakout room. I know you can't see anything because it's just a phone, but your lawyer, Ms. Rios, who tried to meet with you through her investigator either yesterday or the day before, they had a little trouble tracking you down. I don't know why. Cobb said you weren't there. But I want to give you a chance to talk with Ms. Rios so she can explain to you what we might do today, just so there aren't any surprises and you've had a chance to connect. So you don't need to do anything. Stay right where you are. But once you're in the breakout room and Ms. Rios says, hey, I'm here, that's a private space. I can't hear you. The prosecutor can't hear you. So you should feel very comfortable to speak freely with your lawyer. When she's done, she'll let me know. I'll close that breakout room and then you'll be virtually back in here with us. Okay?
Yes, sir.
All right. Let me see if I can make that happen. All right, here we go. We'll see what happens. So Chief Sadler, how are things going with Miss Simpson? So far, it's been great in here.
Yes.
When does she get to fly free of supervision?
Listen, this is my first time working with her in court.
Really?
Yes.
They changed my chief.
Oh, you moved to, who was with you? So for drug court, I know Officer Evans, I know you, and there was a young lady seated to your left.
She is Judge Krause, court specialist.
Oh, okay, so she was seeing how drug court, is she new to Judge Krause?
Yes.
So she was seeing how drug court works? Okay, it was a long one.
Actually, I think she'll probably be doing the drug court with Krause on the days that Krause have drug court.
Mm-hmm.
But yeah, we're gonna see how that goes.
So Officer Evans won't cover drug court anymore?
She's gonna now be a farmer.
That's her full-time thing. Farmer's good, so she'll be all right. So we don't then have, we've always had one probation officer cover all the accountability courts.
That's two things.
Calhoun,
It's always been an officer.
Yeah.
Because when you guys needed a warrant to be done,
right,
that officer was able to do it.
yeah,
And that dawned on me earlier today.
Yeah.
To have that conversation with EXO, because now.
It's gonna be a two-step process, and sometimes we need them, like, we had, you saw that guy who you didn't know, we did terminate him, the guy Arthur Jordan who shot at his wife. I said, I don't know if I'm gonna terminate, you're about to have your prelim down with Judge Brooks, and she found probable cause for the shooting. So he's terminated, but that means right away we need to get a warrant because I don't want him getting out. He needs to come back and deal with the fact that he got terminated from drug court. So you guys are just going to have to develop, I don't know what that process will be.
And I don't think that part was thought about when we made this decision of doing that.
Yeah.
But I thought about it earlier today, and I'm like, I need to ask her.
EXO, what's the magic going to be?
How are we gonna cover that?
Mr. Finley's situation, Mr. Rao, is pretty much sorted out between you and I'm seeing if there are folks we can let go. Have you and Ms. Rios talked about this, or you're going to wait to hear from her?
I haven't talked about it with her, my understanding is, I think based on her previous announcement that.
Oh, she just popped back, so we can sort it all out. Ms. Rios, are you and Mr. McDaniel done?
Yes.
All right, I'm gonna see if I can get him back to the main session. There we go. Hey, I can see you now. Hey, Mr. Finley.
Hey, how you doing today, sir?
I'm all right. Did you have an opportunity to speak with Ms. Rios?
Yes, sir.
Great. Then we're going to get on the record in your case. This is 21 SC 177645, State versus Finley. Your underlying charge was possession of cocaine. And in October of 2023, so a long time ago, I signed a warrant that alleged that in August of 2023, a warrant had been issued by Atlanta Police Department for you for simple assault. I don't think I've signed many warrants like that where it just says a warrant was issued as opposed to you were arrested for. But I'm going to let Ms. Rios talk to me a little bit about that in a second. The first thing I want to do is hear from probation, and they're sitting here in court with me. How much time remains on your case?
He has 2 months and 12 days.
All right, you are almost done, Mr. Finley. You got 3 months and 12 days left on your probation. And if I look up your case.
Can I add, he does still have active probation.
Oh, different duration?
Yes.
Okay. So you got a case out of a felony case? Okay. That number I gave you is just for your Fulton case, Mr. Finley. Ms. Simpson from probation is telling me that you've got another case from Cobb County that has a longer term to it. So whatever we do today may end up coming pretty close, or it may in fact resolve it looks like it's going to resolve your Fulton case. But you're still going to be on probation. It'll just be for that Cobb case. Is that a surprise to you, or did you know that?
No, sir, it's not a surprise.
Good. Okay. Want to avoid those. Ms. Rios, it looks like Mr. Finley has been in our custody for 87 days, which is really close to 3 months and 12 days. Is he admitting to this allegation? And tell me what exactly it's about, as best you know.
He wasn't even, he didn't know that it was taken out until I talked to him. He doesn't know anything about it, but he is stipulating that it was taken out. And so we're okay with going forward today with the revocation hearing. Okay.
So all that means, Mr. Finley, is you're saying, yeah, I agree there was a warrant taken out. I'm not saying I did anything, but sure, there was a warrant taken out. What are we going to do about that? And that's what I'm going to now ask Ms. Rios. What are you recommending we do given that stipulation?
Revoke the 87 days or 3 months, well, a little over 3 months. No, it's almost 3 months. Revoke that time and terminate the balance since that's all he has. I think he's been in custody. I know on our end it says 87 days, but I think in total he's may have been in custody a little longer, but I'm not sure about that number. And
why would he have been in custody? Because he was arrested in a different jurisdiction?
I thought so. When I was emailing, maybe I misunderstood. When I was emailing with Ms. Simpson, she said she was asking for that time to be revoked, and he's already did it. Is that correct, Ms. Simpson?
Just shy of almost 3 months.
Oh, okay. We were talking, the numbers were so close. Let's just say revoke time served.
Yes.
Okay, got it.
But he is 40 years old. He does have a place to go to whenever he is released. He has 5 children and a newborn baby that he has not seen yet. And prior to being arrested, he was working at security at North DeKalb Mall, a jewelry store, and other locations.
Okay. Mr. Finley, what is the case out of Cobb for which you are on probation? What are the charges?
It's actually a firearm case.
Okay. All right. And is it, Ms. Simpson, just one case he's on probation for out of Cobb? All right. Mr. Rao, I know you're just parachuting into this. In some respects, I am as well. We got a gentleman who only has 3 months and 12 days left on his probation. He's served about that. Recommendation is revoke the amount he served and close the case out.
That was going to be my recommendation, Judge, and especially since he has active probation in Cobb, which I didn't know. The last conviction I see from my criminal history report, which could be incorrect, was a theft by taking out of Rockdale County. And the last Cobb conviction I see is for aggravated assault in 2005. But given that information, I think we just terminate probation.
Okay. Ms. Smith-Mann, do you have anything in your system about what conviction has resulted in that Cobb County probation for Mr. Finley?
For the Cobb County probation 6/27/23. 4 years. Is that the one, Your Honor?
Whatever one he's on probation for now. Yeah, I'm just wondering when he got the conviction and for what.
Well, this one tells me is 4 years probation. It looks like, but I'm going to pull it up and I'm not going to read my paper. I'm going to look at the history that I have.
Okay.
Just so I can make sure. Okay, let's see. Mr. Finley, 6/27/23. There is 23. And there is no, that's 2017.
Let me ask, we may be able to short circuit it. Do you all know from probation, what is the case that he's on probation for?
The indictment number is.
I don't need the indictment number, but what the charges were and maybe when the conviction was.
The charges were possession of firearm by convicted felon, felony, and a misdemeanor violation of traffic motor vehicle law.
Okay.
And he received, the sentence date is June 26, 2022.
Okay, that's all I needed. And that's exactly what Mr. Finley was saying. Is like, hey, it's a gun charge. So it's possession of a firearm by a felon, and he's got some more probation left on that. I think I've got all the pieces I need. Mr. Finley, I do find you violated the terms and conditions of your probation in your case here in Fulton by having a warrant issued for you for assault. I don't think anyone knows what happened with that warrant. That was a year and a half ago. But you've been in custody on this warrant for about 90 days. So I will revoke 87. That's what you've been in. And I will terminate the balance with the knowledge that you're going to remain on probation and thus will be supervised. It'll be out of Cobb County. And I assume the residence you'll go to when you're released is in Cobb County. Is that correct?
No, sir. It'll be in Fulton, actually.
Oh, okay. Well, let me make sure that the officers here know that you're reporting to probation in Fulton. Do you have a good, do we need to get a new address for Mr. Finley, or is he in your system as supervised out of Fulton?
His current probation, supervision is being in Cobb County.
Okay. Well, let's close the loop on that because Mr. Finley is saying when he gets out, he's going to live in Fulton.
Okay. They're not transferred. They'll need to update his address with them so that they can.
So he should start by reporting in Cobb and say, here's my new address in Hapeville. I'm making it up, wherever it is. And he'll get bumped down to us. Okay. Were you able to hear that, Mr. Finley?
Yes, yes.
All right. And within how many hours? 48 hours he should get to Cobb probation?
Yes.
Do you know where the Cobb County probation office is?
Fairground.
Fairground, does that ring a bell? I don't know.
590 Commerce Park Drive.
Correct.
102. Marietta, Georgia.
That's the address you know, Mr. Finley?
Yes, that's off of Fairground. My bad, sir.
Okay, that's fine. It may well be. We're not Cobb folks. But as long as you know how to get there, within 48 hours of your release, and you may get, well, 48 business hours, you may get released over the weekend because it's Friday. You got to show up at that Cobb County probation office to say, here I am. By the way, my new address is wherever it is in Fulton. Where do you live in Fulton?
2788 Argyle Drive.
Oh, that's what's on your warrant. Okay, 30318. I don't know why that's not in your system. On the warrant is the Argyle Drive.
They have the longest running case.
Oh, okay.
So whenever we're doing warrants.
Okay.
It goes back to
The jurisdiction. Got it. Oh, that's why. It's because your case that remains is your Cobb case. So you start in Cobb, tell them I live on Argyle, which is clearly your address. It was on this warrant from a year and a half ago. And they'll say, okay, we'll switch it down to Fulton. And then from then on, you'll be reporting out of Fulton. Okay.
Yes, sir.
Mr. Finley, any questions about anything we discussed?
No, sir.
Ms. Rios, anything else on behalf of your client?
No, Your Honor.
All right. Mr. Rao, anything on behalf of the state?
No, Judge.
I got your email about position 13. I will get an email out about what's going that first week for Judge Emerson. Not a ton left, and a lot of it's been bumped to week 2, but we'll see what happens. I'll let you know.
There.
All right. Thank you, Ms. Smith-Mann, for being here. Thank you, everyone, for dealing with a couple of our technological hiccups. Enjoy next week. I'll be out of your hair for a week, and then we'll get back to it in the last week of January. We've got a meeting to prep for the trial calendar and a call of a trial calendar on that Thursday. And Mr. McDaniel, Officer McDaniel, thank you for letting us use your phone. Send us the bill.
Have a good one, y'all.
All right. Thanks, everyone. Bye-bye.
Bye.